Welcome to the Estate Professionals Mastermind podcast, built for real estate professionals that want to work less, earn more, and make an impact in their community. For information on how you can become part of the estate professionals community, visit probatemastery.com. All right, guys, welcome in. It's good to see everybody. There's Lou. Lou, are you co-host? Let's make you a co-host if you're not.
Check it out.
You're good. All right, awesome. So welcome in. This is the Estate Professionals Mastermind. Last couple of weeks, I've run late getting this thing started every week. I had to set an alarm on my phone on Tuesdays right before this call. I have a small group role play with some folks in the coaching program. So you guys, if you've been sitting here for a couple of weeks waiting on me 3 or 4 minutes after our 2 o'clock kickoff time, I apologize. I now have a phone alarm set to make sure that I'm not late on you guys anymore. So this is the Estate Professionals Mastermind. It gets turned into a podcast and YouTube video after the fact. So if you guys have ever missed any of these that you want to go watch, you can go look up the Estate Professionals Mastermind podcast on your favorite podcast channel, or go to Probate Mastery on YouTube, and you can see some of these. Conversely, if you guys are on the podcast platform or on the YouTube channel and you've never been here live, this is a free call that anyone can join. All you have to do is go to probatemastery.com up at the top of the page and sign up for the free weekly coaching call. We'll send you the reminders. We also send a copy of this recording out. Normally, I believe it's on Sundays, if I'm not mistaken. Queenie puts that out for us. So I want to welcome everyone in. This is kind of a live Q&A type of session. So what I really wanted to do is start by talking to you guys today. I've run into a lot of confusion, most recently about 30 minutes ago, on what probate actually looks like for your average client. Yesterday, I made a follow-up call to one of my leads that my ISA generated for me. And I called her and I said, "Hey, I understand you're in probate." And she said, "Honey, my probate's done. Probate is finished." And I was sitting there looking and going, "Hey, you just applied for probate 30 days ago. Probate is not done." So my conclusion was that she's either lying, quite possible, or more than likely, she's utterly confused about what probate actually is and what goes into the probate process. And so I wanted to give you guys a little bit of a breakdown of everything that goes into probate. And this is going to make a really good added lesson inside of Probate Mastery. So if it goes really well today, we're going to put this inside of Probate Mastery and kind of let those of you that have the certification program go in and rewatch this and kind of really thoroughly understand. And if you want to be able to explain it to some of your clients a little bit better, you can create even a document for this. This is a document that goes inside of my resources packages. When I get a lead, someone into my pipeline, and I say, "I'm going to send you a resources package," this is a document that I actually would put inside of those resources package, that resources package, to help them understand probate. So bear with me. I am not going to give you my resources package. I'm not going to give you my document that goes in my resources package, because I don't want too many people sending the exact same identical looking document out. And I have some coaching clients that have my document. So I'm going to give you guys a different version of it. So I'm going to Claude AI right now to recreate a breakdown of what that might look like. And as soon as it kicks it back, I'm going to share my screen, and we're going to go over all the things that happen during the probate process. All right. So screen is shared. If you're listening on podcast, you guys forgive me. You're going to have to go over to the YouTube channel, again, Probate Mastery on YouTube, and find our weekly coaching calls section, and go through this if you want to see the screen share. So first thing that happens, someone passes away, a loved one passes away, and theoretically, this starts normally within about 3 to 4 weeks. There are some people that go much faster than this, and they're down at the courthouse 3 or 4 days later. It's a little bit unusual. It's also unusual that people wait years to start probate, but that does periodically happen where people might wait years to start the probate process. So, um, regardless, as soon as they start, a family member, normally a family member, sometimes it's an attorney, is going to go to the courthouse. They're going to go to the clerk's office and they are going to apply for probate. In my state, North Carolina, the clerk asks the person, "Do you have a copy of a will? Do you have a will?" If the answer is no, the family member will then apply for estate administration. Estate administration, if there is a will, they apply for probate. Now, that is basically the way that the country as a whole works. Every state has slightly different processes. Sometimes the state looks at the process identical. They say, will, no will, you're going to apply for probate either way. In my state, if there is a will, you apply for probate because you have to probate that will. If there's not a will, you apply for estate administration. Doesn't really matter. That's all semantics. Anyway, they're going to apply. They're going to basically petition to begin the probate process. The clerk at that point is going to pull out a calendar. Either, ironically, in my high-tech city of Raleigh, North Carolina, they pull out a book, just a paper book with a calendar in it, and they look through and they say, "I have court dates and times available here, here, and here. Which one of these works good for you?" And so they'll actually choose your court hearing with you right there, out of a book, and they'll pencil you in and you put it in your calendar. So step two of the probate process is you're going to schedule your hearing with the county's probate magistrate or probate judge. Don't worry, guys, if hearings are done with a judge or a magistrate. Some counties do it with magistrates that are kind of unelected. Some of them do it with judges that are elected. So you'll go to a hearing as the family member. You'll go to the hearing and present your case, present your application, present your will, your death certificate, a list of heirs, a list of assets, any supporting documents you have. You'll do that as the second step in the process. If the court likes what you've submitted and there are no major errors on it, they're going to issue a letters testamentary, which is essentially your authority to officially begin the probate process. So on a call just a little bit ago, and someone said, "Bruce, everyone I talked to is already through probate. They're done with probate." And I said, "Why?" They said, "Well, they all have letters testamentary. Probate's done." Well, no. Letters testamentary means that probate is officially begun. Okay. You are not in probate until you have your letters testamentary. Letters testamentary could also be called letters of administration or letters of authority. There's a lot of different names for it. If you look in a legal dictionary, it's going to be called letters testamentary, and this just says this person has been appointed as the executor or administrator to oversee this probate process and oversee this estate. So what the family needs to do, what the executor needs to do at that point is they need to set up their estate. So just because they have their letters of authority doesn't mean that the estate isn't set up. So the first thing that they need to do is go establish a legal entity. So they're going to go into the state's Secretary of State's office or onto the Secretary of State website, and they're going to register or create a legal entity for the estate. A lot of times this is going to be an LLC. I don't think it has to be an LLC, but you're going to go to the state Secretary of State website and you're going to create a legal entity with the state. Once you have your legal entity, you're going to go to the IRS website and you're going to apply for a tax ID number. So right now we are in the throes of setting up and creating our estate. We are officially beginning our probate process. Once you have your tax ID number, you're going to take your tax ID authorization, you're going to take your Secretary of State articles of organization, you're going to go to your bank, and you're going to open up a bank account in the name of the estate. So you've got to open a bank account in the name of the estate. If granddad had a bunch of cash sitting under his mattress, that money has to go in the estate's bank account. Should not just be sitting loose as cash. There needs to be a legal accounting of the money and the assets that are involved in any liquid asset, cash, needs to be put into the estate's bank account. Okay. If it's an asset like stocks, bonds, mutual funds, things like that, the name on those does need to change over to the estate. So they need to be notified that I have this legal entity, this person's passed away. I need the estate's name associated with these investments. All right. So they're going to open an estate bank account. Next thing is you move into a notice of interested parties. So notice of interested parties. In the majority of cases, and we're going to look this up, I'll have everyone do this independently. In the majority of cases, you are going to have approximately 60 days after you get your letters testamentary to run an advertisement in the newspaper. So the court's going to say on your letters testamentary, within 60 days, you have to run a notice to creditors in the newspaper. All right. And that notice to creditors is essentially saying, hey, this person's passed away. We officially have an estate. We're in probate. And if we owe you money, here's where to send your bill to. Here's who to contact if we owe you money. If you're an interested party, so let's pretend that there wasn't a will and you are a relative, you might see that and you might contact the estate administrator and say, hey, don't forget about me. I need to get a piece of this estate. So that happens there sometimes. But you've got that certain window of time to start running a notice to creditors in the newspaper to let them know if they're an interested party or they're owed money, how to get a hold of you. So you're going to run this, and they normally have around 90 days from the date that you run your first ad. So normally, state dependent, around 90 days to submit their bill. So I talk to people pretty frequently that have started probate, they've gone to court, they've gotten their letters of authority, and they say, hey, probate's done. I don't need anything. Probate's done. And in their mind, they think it's done because they've run their first newspaper advertisement, their first newspaper notice. And they still have a year's worth of work to do on probate before it's officially done. So could they be lying to you when they say it's done? For sure. They could be lying. They could just be trying to get rid of you. More likely, they're just really confused as to what is going to go into the probate process. So they run their letters to creditors. At that point, it's time to start managing assets. So they're going to want to do a full inventory on a court document, a full inventory of all their assets, and they're going to want to start getting an evaluation of those assets. An evaluation of assets is not mandatory. The court's not going to force an evaluation of assets. It's a really good idea, though. Really good idea. And I'm going to tell you guys why it's a good idea, and then I'm going to go to Lou, who probably has seen a good question chatted in that I need to answer. So there's something called a stepped-up basis when it comes to inheritance and capital gains taxes. And what it says is if you're a family member whose loved one has passed away and you're inheriting wealth, house, vehicles, assets, anything like that, you don't have to pay taxes on the inheritance at the value that was there at the time your loved one passed away. So if I inherit a house from a relative of mine, and on January 1st, when they passed away, the value of that house was $500,000, I don't pay capital gains or estate taxes on the $500,000. I do pay taxes on any increase of that $500,000. So if I inherit a house and 6 months later I sell the house and it was worth $500 on January 1st when my loved one passes away, but on June 1st it's worth $550, I'm going to have to pay taxes on the $550, on the $50,000 increase. So what happens really frequently with families that don't evaluate their assets early is the IRS looks at their assets and say, hey, we think it was worth 300K. You sold it for 500K. You owe taxes on 200,000 of increase. Or if they don't get an evaluation, the IRS might go off of what the tax assessed value is. How many of you are in a market where the tax assessed value is still rather low compared to what actual market value was? So I just had a client a couple of months ago that inherited a house. Tax assessed value is 427. They sold the house for 600,000. If I hadn't given them an evaluation of their house that said it's worth 600,000 at the time your loved one passed away, they would owe taxes on almost $200,000 worth of gain. They didn't know. Most families don't know that they should officially evaluate their assets. So this step is where they're starting to manage, they're starting to list their inventory of assets, and they're starting to get evaluations on their assets: houses, art, firearms collections, vehicles, furniture. They need to get an evaluation on those assets. I'll move to financial management in just a second. Lou's had his hand up for a little bit, and I don't want to move past the question that we've had come in.
Yeah, so earlier Lindsay asked if you have an attorney, they take care of all of this for you, right?
No,
No.
no. Um, a good attorney who has a great relationship with their clients um, probably knows all this. They have a great relationship. They're most likely hand-holding and making sure that they're taking care of as many of these things for their clients as possible. But there's still a lot of steps that they are going to coach their clients through if they're a good attorney with a great interactive relationship with their clients. Okay? Not all attorneys are good attorneys. Not all attorneys have a great interactive relationship with their clients. I would argue that a lot of these steps, I don't know many attorneys at all that are going to handle all of these steps for a client. Now, the client might think so, but it's not going to happen, even if it's a good attorney. So the good attorney is going to do a bunch of this, probably take care of everything here in the top. A good attorney is probably going to help with the petition. They're going to go to the court hearing and help with that. They're going to help establish the legal entity. They're going to probably run the local news advertisement. Probably, they might not. But then when it comes to asset management, no, it's pretty much the attorney's done a bulk of their process. It's time for the client to take over. The attorney's not going to go in there and list all the assets out and get an evaluation on all the assets. That's up to the client. A good attorney will coach the client how to do this. A bad or neutral attorney isn't even going to tell the client how to do any of this. The client's going to be completely in the dark on everything from this point down with a lot of attorneys. And this is where I run into people all the time that say, my attorney's doing everything. It's all covered. Now, last thing I want to do is tell the client you're wrong, because then I'm kind of creating a combative situation. But I need to recognize that the client is really misunderstanding what the attorney's going to do and what they're going to have to do. Okay.
And a follow-up question to that, who's the person that could do this valuation? Can a realtor
Yes.
do it, or is it an appraiser?
So just like you file your personal taxes, so we all have business expenses, and let's pretend I get to the end of the year and I'm doing my taxes, and I say, hey, I drove 30,000 miles this year for my business, and I put that on my taxes, but I don't have proof. All right, I don't have proof. I didn't track my mileage. I didn't keep my receipts. I put it on my tax return. There's probably a 95 or 98 or 99% chance that I get away with it. But if I ever get audited, I have to be able to show proof where I got that mileage from. I have to be able to show proof. And if I can't, I didn't get the mileage. I got to go standard deduction at that point. So the family, they're doing these evaluations for their taxes. Right. If they don't get an evaluation, and they just randomly put some number down and they get audited, they have to be able to show where they got that number from. And if they didn't get the number, they're probably going to have to go back to tax assessed value. So what they need to do is just be able to show some kind of documentation of where they got that number. It could be an official appraisal, which is the safest, but it costs money. It could be a broker's price opinion. It could be the tax assessment. It could be a CMA from an agent. It could be something verbal from an agent. That's probably the least acceptable is an email that says, "Hey, I think you're worth 500,000." But they want to be able to show some kind of documentation of how they got that number. And if they're going off tax assessment on any asset, it's probably low. Hey guys, I'm butting in here with a quick ask. If you're getting value out of this coaching today, I want to invite you to check out my Probate Mastery trainings over at www.probatemastery.com. Probate Mastery is for you if you're an agent or an investor that wants to work with motivated sellers that have inherited real estate that they don't need and in many cases can't afford. These sellers are more appreciative, willing to trust your expertise, and less likely to nickel and dime you over commission or price. Why is that? They're often in the middle of a complex probate or an estate administration process, and this means that real estate is very often a burden on them, and they simply need the help. Inside of Probate Mastery, I teach you exactly where to source your leads, how to establish value, and offer your service in a way that quickly makes you, as the professional, your market's expert in the probate space. If you want to know a little bit more, go over to www.probatemastery.com. Hope to see you guys inside of the community. Thanks. All right. Anybody else have anything to chime in on before I move to financial management?
There were a couple of other questions.
Mhm.
Let's see. On the topic of the estate bank account, does it have to be in the same state as the location of the property that's going to probate?
I don't believe so. That would be one I would run by an attorney. I don't believe so because a lot of times assets, people will have assets in multiple different states. So I'll sometimes see probate cases that are filed here in North Carolina, and all the assets were in Florida. And there was one asset up here, or maybe the attorney was up here and they're running it here. So I don't believe that it really matters if your bank account is in the estate, but please don't take my word for that. Go confirm it with the attorney of your choice.
And then the comprehensive valuation, like what items should they, the clients be focused on, reporting.
Oh yeah. So they're gonna want anything. My general rule of thumb, and I haven't seen this on the estate side of things, but my general rule of thumb is anything that has a yard sale value of more than $500. And that's kind of the rule with foreclosures and different things like that. Is if you could put it out on the in the yard as a category and it's gonna bring more than $500, you should probably get it evaluated. All right. So firearms, furniture, art, um, vehicles, tools, household belongings, real estate, that farm equipment. So anything like that that's kind of in its own asset class is probably going to count. If it's something that's pretty cheap, hey, I had a couch that we've had for 10 years and I could yard sale it for $100, probably not gonna really come back and bite you. All right. So
Thanks.
finding, yeah, thanks, Lou. And thanks for the questions, guys. So at this point, they want to start making sure that they're collecting any income that's owed to the estate. So it's more than just what the estate owes, but sometimes there's income owed to the estate, and the administrator or the executor can get themselves in a lot of hot water if they let that slide, especially if there's other heirs that are relying on them to maximize the value out of that estate. Eva,
Hey, sorry, newbie agent here, but
you're
like
good.
real quick on the listing agreement. So when you go to meet with them and there's still a lot of work to be done, how do you, do, is there, I'm sorry, I really need to study that thing, but is there, you can put the actual listing date out a bit, or like how do you
Sure.
the deal?
Yeah. Yep. If you want, yeah, obviously talk to your broker as a new agent, talk to your broker, but if you can put the marketing date out. You can put the marketing date. So listing date, if I'm getting something signed and I want that commitment as a listing agent, I'll get it signed today. And maybe they say, this house is a mess and I don't want it on the market for 2 months. I'll put the marketing date out until the family is going to be ready. So I'm all about getting things signed today if I can get a client under agreement today.
Oh, great. So I don't need like a separate form, right? Okay.
No, please do talk to your broker and just make sure that we're doing what your broker wants, internal
Okay.
policies, or your state wants. But in my state, I could say, hey, I listed this on September 23rd, but my client's not going to be ready until November 1st. And so I put a marketing commencement date of November 1st. And then I have an agreement. We're locked up. If I wanted to get them locked down in a relationship with me, then I've got what I need, and I don't have to start marketing right away.
Okay. And what does that mean though? I mean, does that mean there's actually a listing, but you're just not actively?
Yep. Yep. You have an active listing, and not an active listing. You have a listing. They're in relationship with you, contractual, but you're not
It's not like
promoting it
on the
to the
MLS.
public. Yeah, you're
Or,
not promoting it to the public at
okay.
that point.
Okay. Thank
Yeah.
you.
Good. No, thanks. Good question. So they need to pay ongoing, so they need to manage finances. This is going to be another step of the process. There are some ongoing responsibilities, and it's court reporting. Every state, every court system is going to be a little bit different. Most court systems need frequent reports. It might be quarterly, it might be monthly, it depends on your court system, but they need reports. What have you done? What have you not done? What are you going to do next? So frequently you're submitting all throughout this probate process, you're submitting updates to the court on official court documentation saying what's done, what assets are left, what's been sold. I've got my EIN. I haven't set the bank account up. You're reporting those things. In some cases, you're making modifications and you're correcting court documents that you've had before. But all through this period of time, they're submitting updates to the court. If they have an attorney, this normally is what the attorney's doing. Sometimes the attorney's not doing any of this. Sometimes they don't have an attorney at all. If it's a good attorney, they're probably staying on top of this. Again, please don't be fooled into thinking all attorneys are good attorneys. There's a bunch of us on here that are real estate agents. Are all real estate agents good at their job? No, no. So if we're not all good at our job, just because an attorney went through law school, they're probably more educated than most of us. Okay, doesn't mean that they're properly handling clients. Some of them are great, some of them are not good, and I think that they would agree with me. All right. So you got to keep records of transactions, things like that. You have to make sure that you are up to date on your tax obligations. So I mentioned earlier, you have to file a tax return for the decedent. I've said this once today, and I don't remember if it was earlier in this call or if it was on a coaching call. If the decedent passes away on January 2nd, 2025, the family is going to have to do a tax return for the decedent for 2025. So before you can close probate, you're going to have to show that you filed a tax return in the year that they died, even if they were only alive one day of the year. You got to do a tax return for that year. Then you need to file another tax return for the estate. So a separate tax return for the estate itself. So there's two tax returns that are going to come into play. And then obviously pay any taxes. So government wants their money first before even debts can be paid. All right. Finally, you're going to do a final accounting. So you've done all these things. You've managed assets. You've sold assets. Big mistake people make. I know agents and investors that make this mistake too. I've won business because investors made this mistake. I've got a really A good friend of mine who I won business away from. I kind of hated it, but I didn't hate it. He told the family that they were not allowed to sell the asset, the house, until probate was closed, completely closed. Not true. As long as the family has their letters testamentary and the authority and the approval to sell assets, they can sell an asset long before probate closes. Now, what they can't do is they can't take the money from that asset sale and give it to family members. So they owe 300,000 on a house. They get their letters testamentary in the beginning of the process from the judge, and when they sell the house for 500,000, there's 200,000 of equity there. They can't give that 200,000 to their family members. They have to put the 200K into the estate's bank account, and then that is given to the family after probate is completely closed. So to close the estate, they give their final accounting with a report of everything that's kept, everything that's sold, what's been paid, what's been left in the estate, and then the court is going to give them the approval to close the estate out and pay the heirs any remaining assets or any remaining money. Okay? So this is basically the court process. In the majority of our locations, this is going to take 12 to 15 months. Can it happen faster? Yep. I talked to this lady yesterday who told me probate's done. Not sure why you want to send me a resources package. Probate is done. And I looked and I saw that she filed 45 days ago. Probate's done? No. What she thinks is that her letters of authority was the probate process. Now, I didn't say, hey, you know what? You're wrong, dummy. Then I don't have a relationship anymore. I said, hey, that's great. It sounds like you really had a good, smooth probate process. Things were really in order. And she said, oh yeah, everything's good. Everything's good. And I said, well, what I'll do is I'll send you a little packet of some resources that'll help you button up any loose ends that you have. You probably don't have any, but if you do, you can call me. Is that fair? And she said, yeah, that's fair. And then I started digging into the things that she hadn't done. I'm assuming that you guys probably have already taken care of the final accounting, right? No, I haven't done that. You probably got your evaluation on the house, right? No, I haven't done that yet. So I just started poking holes in everything you're done after I kind of accepted the fact that she thought it was all done. So that's what we want to do. But we really need to understand what's going to go into this process if we're going to serve this community, because people are mistaken all the time. We'll have competitors that are mistaken. We'll have judges that are sometimes mistaken. We'll have lawyers that might not be mistaken, but maybe they're not doing their job. And as a matter of fact, we'll have lawyers frequently that are mistaken. How many of you have done a probate deal and had a lawyer involved that was a general lawyer, maybe a real estate lawyer, and they were trying to administer a complicated estate? Right? Happens really, really frequently. It's one of the reasons I don't only go after specific probate or estate attorneys. I talk to other attorneys because they get involved in probate all the time. Should they? Probably not, but they do. So people make mistakes in this process, and it's one of the reasons why we as a professional really need to understand and be able to help where maybe the attorney's dropping the ball or the client's confused or something, cases like that. Let's go to Kai. I saw David's hand go up, but it came down. Kai, I'm assuming it's Kai, right?
Yeah, it's correct. Can you hear me okay?
Yeah.
Okay, yeah, and I'm in Tennessee. I'm not sure if it's similar for other states, but here, even if there is a will, you need an explicit power of sale clause within the will. So a lot of times, if especially if it's like intestate or the will doesn't have that, you have to get the court's approval. How long does that take typically? I'm not sure if you know the answer. It's different for every county, but yeah, that's my question.
So I hate to do this. I hate to ask my AI, because then you guys are going to ask AI and not ask me, and I want you asking me. I'm assuming that if there's not a power of sale clause in the will, then you probably have to get the court's permission at the time that you're sitting in your hearing. So most likely you're gonna do your petition, you're gonna go to your hearing, and you're gonna list out your intentions with those assets. And if there's not a power of sale clause in the will, they should give you your authority, your permission, including the selling of assets. It's a huge mistake that people make holding on to assets too long. They have to be sold in a huge portion of situations. And if somebody made a mistake at the time that they wrote a will, the family shouldn't be punished by losing massive amounts of equity just because there's not a power of sale clause in the will. So, short answer, according to to Claude AI, it depends on what the will says. But the longer answer is even if it doesn't have a power of sale, you're going to be able to sell. You might just have to go to the court and ask for approval, which they'll give.
Okay, thank you.
Yeah. In some states like California, it depends on how you apply for probate. So California only, if you're not in California, you guys just, this doesn't apply to you. So California, when you apply for probate, you get a limited authority or full authority. Limited means you have to get the court's approval on everything that you're doing, everything you're selling, what the sale value is, et cetera, et cetera, et cetera. It makes the process really long. It racks up lawyer fees. Full authority means you as a family can pretty much make decisions autonomously without having to go beg the court for everything. Tennessee, if there's not a authority of sale, I got the name wrong. If there's not that, then you probably are going to have to go and at least get one blanket approval from the court if you're going to be selling assets.
Okay, thank you.
Yeah. So general way that I would approach it, it's not because I know Tennessee law. All right. Who else, guys? Let's move to questions. Hopefully that clarified a few things for you all. I like to put that if I have a great conversation with a lead and they're not ready to do anything yet, I like to put that inside of some of the resource or marketing material that I'm going to send them over time. Hey, Lou, what do we have?
Yeah, there's a question in chat from Lindsay. For a home sale without a will that's in probate, are there situations where you would want to wait longer to sell the home for a better market?
So the administrator, let's kind of talk semantics here, and this is fun to know. If you guys don't remember this, it's fine. It's not going to hurt you in this space, but it's fun to know. When there is a will, and you go to your court hearing, the court will issue letters testamentary, and it'll name you as the executor, or executrix. Okay. And it means that you're a family member who was appointed and named in the will to administer the estate. If there's not a will, you're named as the administrator. So not executor, you're the administrator. If you guys want to cut through all the noise and be like, I don't want to remember all these things, personal representative is just a catch-all term. So if there's when you're named as executor, administrator, personal representative, you have a legal obligation to the estate to maximize the value of that estate, a legal obligation. Now, if the other heirs don't care if you wait too long or sell too soon or sell too low or sell too high, if they don't care, if everyone's in agreement, there's really no problem. But not every family situation is the same. So if I'm administering an estate and I've got siblings who are all heirs, whether they're named by a will or by the state, they're all heirs, and one of them hates my guts and is just looking for any opportunity to take me down that they can, and I wait too long to sell the house and the market crashes, they could say, you mismanaged the estate. You mismanaged it. You lost me money. And they could potentially bring suit against me as the administrator. Does it happen? Periodically. Is it likely to happen? No, this is the type of thing that's not likely to happen very often. But if you know that real estate market is skyrocketing and values are climbing as the administrator, you probably want to wait a little bit and gain that extra value if you're in a skyrocketing market. But what happens to empty houses? Most of the time, even in increasing markets, they tend to go downhill. So, in most cases, it's a good idea for an administrator, especially with an empty asset, it's a good idea for them to sell sooner rather than later. Selling later, even if the market's going up, house isn't being taken care of, an empty house goes downhill a little bit. They're paying taxes, they're paying insurance, they're paying utilities, they're costing the estate money by leaving it off the market when they know it's going to end up being sold. So the real answer is it depends. Depends on a lot of things, but families in general, if an asset's going to be sold, it's normally a better idea to sell sooner rather than later. Doesn't mean that they will. They've got other things on their plate. It's just not feasible to do 900 things. You've got your own job, your own life, your own family obligations, social obligations, things like that. And suddenly you're thrust into the role of being an executor. Are you going to drop everything and be a full-time executor and take care of everything in the first month? Probably not. So that's why we see houses that typically take 6 to 8 months before they go on the market. Should they have taken that long? In most cases, no, they should have been sold sooner. Is it understandable why it takes 6 to 8 months to make a real estate decision? Yes, it's understandable. Busy life with someone that's never done this job before. And now they have to make all their decisions and get assets sold early. It doesn't happen for most people that fast. Eva.
Oh, first, thanks to Dave Pennell for the letter video you guys did. I got 2 calls off my letters. Thank you. So far,
Incredible.
and yeah, still working on it. My question is, with my appointment I have coming up, the executor himself, like the brother died, but he cannot physically travel to be here, but the wife will be here, said she has power of attorney.
Mm-hmm.
And so do the daughter and son. Who signs the actual listing agreement? Do I need to get electronic signature over to him?
Yep. It
Okay.
depends on what the Letters Testamentary says. So let me get this right. So brother passes away.
Mm-hmm.
There's a surviving brother that is the executor, correct?
Yes.
This surviving brother's wife has power of attorney to sign on the executor's behalf, correct?
That's what she told me. Yep.
Okay. Getting a little bit complicated, but okay. So she's gonna sign. Um, let's say his name's Bruce Hill. So she'll come in and she'll sign the listing agreement as her name, attorney in fact for Bruce Hill, executor of the estate of John Doe. So really long way that she's gotta have to represent and sign her name.
Okay. It's kind of like how you have to sign for LLCs too. So
Yeah,
okay.
yeah.
Yeah.
So it makes it a little complicated. Now, as far as the listing goes, it'll probably fly with just her signature. When you go to closing, I would do whatever the closing attorney or title company says to do. But a lot of times I'll see, especially if there was not a will, all heirs have to sign. If there was a will, the will usually gives signing authority to one single individual. Normally. It's the rule of thumb, but it's not the rule for all situations. So most likely, if there was a will, it's going to be one executor signing or the wife signing for closing. To get it on the market, you're probably good with just the executor's signature or the
Mhm.
power of attorney signature. But I would ask to get a copy of their letters of authority to make sure that you're handling it properly. So,
Wonderful.
yep,
Thank you for that.
absolutely.
Hey, Bruce, Rico.
Hey, Rico.
Sorry about that. I'm on the road, so I'm trying to focus on the road and hit the unmute button. So forgive me.
You're good.
So, okay, I have a couple questions. So I'm deep diving into all the material, and one of the things that I listen to daily is where Chad is explaining the process of probate.
Mm-hmm.
And the two questions that I want to ask, one is probably so basic you're going to go, wow, I can't believe you don't know this. But how does somebody get notified that there is a will unless it's been spoken of during the whole life of the individual that passes away? And
Yeah.
secondly, how is the the chain of command on when the person passes away and everybody gets paid? You know, the collectors, the all the bills that are paid, the IRS, everybody. What's and I would think that the IRS is number one in everything, I would imagine. But what
Yeah.
throws me off is that he mentions, you know, you have to pay the funeral cost and all that. So I didn't know if that was done before paying the IRS. Well,
Hmm.
I don't even know if they care if you're passed away or not. They want their money. So
Yeah.
those are my two questions.
Good. So, most of the time, if there's a will, it's been discussed. So most of the time, if there's a will, it's been discussed, but not always. If there's not a will and it hasn't been discussed, you're unfortunately kind of left playing the let's go through as much as possible and try to find one. If we can't find one, we have to go to the courthouse and we have to apply for administration. So it's intestate administration. Um, Intestate administration is essentially saying, hey, we're going to follow the state's rules for overseeing this estate and distributing assets. And every state is different. So if you guys want to know, I'm just going to go back to my AI really quickly. And this is just sort of one running document here, but I'm going to pop into my chat and say North Carolina. You guys can do this for yours as well. Intestate administration, order of inheritance. This isn't the official name that you're going to look for, but Google and AI, they're going to know this. All right. So, in other words, if there's not a will, who is entitled to the estate? And normally it's any blood relative or spouse. Okay. So we're going to go surviving spouse with no children. Okay. Children and decedents, then parents, then siblings, then grandparents and extended families, then more relatives. And then if there's no heirs, then it goes here. Now, normally, if there's no will, everybody on that list that I just gave you gets an equal share. I've seen estates that settled where everybody was getting $3,000 on a $400,000 net evaluation of what was left in the estate. So it can get pretty diluted and chopped up. Okay. But it's good for you guys to kind of understand what intestate distribution in your state specifically says. Now let's go back to the second question. Second question is professionals get paid first. So if you're a realtor and you sell a house and your commission is 6%, if I'm not saying it is, so we're not price fixing here. If your commission 6%, you're going to get your 6%. The funeral director is normally going to get theirs, things like that. But once professional fees are paid, then Medicaid, Medicare, they get paid. Taxes get paid. Then debts get paid. So Medicaid and Medicare, then taxes, then debts. So anybody that you owed money to. And finally, the family gets what they are owed. And I might have put the taxes second where it should have been first. I'm going to tell you guys, and I know sitting here and listening to me do quick research is not what you guys are in here for. Okay. I will confirm that here in just a second. Varies by state. I don't know about that. So the taxes have a higher priority than Medicaid claims. Okay, so it's going to be taxes, then Medicaid, then bills, then okay, here we go. All right, you guys forgive me. Administration expenses, so that's your court cost, attorney fees, executor compensation, realtor fees, then funeral and burial expenses, then taxes, then medical, then other debts, and then the family and the heirs last.
Great.
All
Thank
right.
you for explaining that. I really appreciate that.
Absolutely.
Cleared it up.
Yep. All right. What I've found is it really helps if you learn some of these things in order to teach it. And the best way to learn in order to teach is going to be to document everything you're doing. And I would put those things into a resource list or a resources page that you intend to send out to a warm lead in the future. If you can study something, if you can create a document that you plan to send out or you plan to
Really cool.
educate a future client on, it's usually going to stick in your head a little bit better. That's the way that I learn. I learn to teach. All right, Larice, my fellow trianglean.
Hi, how are you?
Good. How are you?
I'm amazing, thank you. Really quick, I have a buyer that's actually purchasing a property, and we're under contract. We found out that there was somebody else that was on the deed. He's actually passed away.
Hmm.
So they show that the will, it was a sister and brother, and so
Hmm.
it shows that he willed it to his sister. So they're asking, the attorney's office is asking for her to send a copy of the will to them, and now she has to get something sent over so that they can start probate in Johnson County.
Hmm.
And is that like a long process or?
Real estate normally does not have to go through probate in North Carolina. Normally, okay? So, title companies and real estate attorneys don't always know this because they do real estate and title. So, if so, it was a brother and sister that owned the house together, correct?
Correct,
Okay. He passed away, and his will said that she got his half of the house, so she should own 100% now, right?
correct.
Should not need probate. Should be almost the equivalent of a right of survivorship if the will was set up properly.
Okay,
Almost. Okay. So I would probably reach out to a probate attorney specifically or an estate administration attorney specifically and just ask that question.
okay.
Do you know one?
I don't. I was
No?
gonna have.
Okay. You can reach out to me. I'll send you an attorney, but I'll tell you anytime I have questions, even if I think I already know the answer, I'm normally going to use that as an opportunity to reach out to a new attorney that I don't know yet.
Okay,
Okay. I just want an excuse to talk to attorneys that I don't know so that I can start to build a relationship and maybe get their referrals down the line. So I know half a dozen attorneys that I have a pretty good relationship. Want to have a question like this? I'm calling an attorney that I don't know because I already
okay,
know them. I want a seventh attorney. Okay. So that's normally how I'm going to handle some of those. I would, based on what you told me, I don't think that they're going to need probate for the house. For the house. It's probably a real estate attorney that doesn't know that, though.
okay.
Yeah.
All righty.
All right. Good. What else? We're coming up on the top of the hour. I do have room if anyone else has questions, though.
Bunch
Hey,
of
Luke.
questions in the chat.
Okay. Help me out.
All right, let's see here. Going back to the top. Is the petitioner the same as the executor? What's the
Normally.
difference?
Normally, petitioner is probably going to be the executor. They just haven't been appointed yet. They've applied and they've said, "Hey, I should be the executor. Please approve me." And most of the time, it's not a flattering job that they would want, but normally they're named or the family's kind of voted for them and they've petitioned, but they still need the court to approve them as the executor.
Okay. Monica has a question. I think
Hmm.
she's out in California. Sacramento area. Mother and daughter own a house jointly.
Mhm.
When mom passes, does the house have to go to probate? They're both living in the home.
So it depends on how the deed is written. If it's written with right of survivorship, it does not need to go through probate. If it's written like joint tenancy, then mom's half of the house probably needs to be probated
It
and go to the other heirs, probably. And I don't know California specific law, but that's going to be
it is written in
it's written what? Go ahead,
it is
Monica.
written the right of survivorship.
Great. Most likely does not need
It-
probate.
Okay,
Yeah. There are
thank you.
maybe other assets that do need to be probated though. So that so often we kind of look at the real estate and we think, hey, real estate doesn't have to go through probate. It gets to pass directly to the heirs. And then we're forgetting that there's assets that maybe do have to go through probate, but it shouldn't affect the sale at all. All right. Um,
We also have,
Thank you.
Thanks.
let's see, when trying to find a phone number
Mm.
for executors or administrators, what's the best way to find those?
Yeah. Either buy your leads with that have already been skip traced. Obviously, that comes with a cost, and they normally have phone numbers associated with the addresses. They've done the hard work of skip tracing. If you just have a list and you haven't skip traced, I would go if I was skip tracing a bunch at a time. I would go to Ben Verified, BEEN, BEEN verified.com. If I was just doing one at a time, I go to propelio.com and I just put those in chat. So did Lou. So Ben verified, if I'm doing a whole bunch, I can buy like 1,000 skip traces every month for 100 and some dollars, and then I can just batch run a bunch of leads through and skip trace. If I'm just doing one off, I'll use Propelio. Um, but that's not because those are the two best skip tracing services that are out there. There's tons. Those are just the two that I use.
Cool. Another question from Lindsay. For a regular administrator, do we just use their name in the listing agreement and the sales contract?
Well, so an administrator is normally not an executor. Normally, an administrator is overseeing an estate where the court appointed them. They might still be a family member, but a will didn't appoint them. And in most cases, if you're the administrator and the court appointed you, it depends what your letters of authority say, your letters testamentary say, but normally you need all the family members to sign, which can be a little bit of a chase. Um, it may not be that, like, you could probably get by listing a house with just the administrator signing. You're probably not going to get by closing on the house with just the administrator signing, most likely all the other heirs. Now, if you're dealing with a full executor who is named in the will, normally they have signing rights to sign on everybody else's behalf. That's not the rule all the time, but it's usually a safe bet that they're going to be able to sign for everybody. All right.
Okay. There's another question from Sam, or a question from Sam.
Yep.
What about calling an attorney who is also the executor? How are you handling that? Are you calling him?
Yeah, I'm not calling about the estate though. That's just me. My approach is to never say, "Hey, I'm calling about the estate of so and so." The only time I do that is if I've already talked to the family member and they've said, "Talk to my attorney." And I'll ask, "Hey, do you mind if I call your attorney?" "Yeah, sure, go ahead." And then I'll call and say, "Hey, I spoke with this person, this family member. They said that I could call you." Okay. If I just see the attorney's name on the list as the executor, I'll call about the fact that in the last year or so, I've had a couple of clients that were going through like a probate process, and I just realized I needed a good attorney that could help with those types of things. I was wondering if that's the kind of work that you did. So they don't need to know that I see their name on a list. They don't need to know that. Of course, they're going to say, "Yeah, that's what I do." If I ever had anyone going through that again, would you be interested in those referrals? Why would they say no? Yeah, of course. Think I could meet you and see your practice one day next week? Why would they say no? So I'm trying to lead in that way. So I build attorney lists off of my probate list all the time, but they don't know that I'm looking at a probate list.
Okay.
Hey, Joe.
Okay, I want to make sure I understood what you said, Bruce. You said I was under the assumption if you're appointed the executor in the will, okay, that you had the authorization for everything. But what you're saying is that the court could appoint somebody else, right?
If you are challenged or deemed incompetent, then the court can appoint someone else. Can. They probably won't. So if you're named in the will as the executor, it's not much chance that you're going to get kicked out of that seat. But
Okay, yeah,
but
because
it is possible. It is possible.
I ran across one where I was talking with the person was complaining. They were appointed the executor, but they got his sister that's a control freak, and they're flipping out and they saying that they want to take him to court and all this other stuff, you know.
Sister, to a degree, is SOL. Um, unless she can prove that they're not capable of administering the estate. If I was a family member and I was named as the executor in an estate, and my sister freaked out over it and said he shouldn't be the executor, I should be the executor, go for it. I don't want to be the executor. I called an agent on my team. This happened a couple of years ago, and at the time I was doing the coaching over for all the leads and was not running probate mastery. So I was doing that coaching, and he knew, like I'd been doing probate for a long time, and I knew I was coaching. He was on my real estate team. We talked every day. And one day I was talking to him and I could hear road noise in the background. I said, "You're in the car, aren't you?" And he said, "Yeah, I'm just driving to Washington, D.C., which is about a 5 to 6 hour drive, depending on traffic. Let me say 5 to 8 hour drive, depending on traffic." And I asked him what he was doing, and he said, "I'm closing my aunt's estate out up here." And I was like, "Oh, yeah, what's that been like?" And he said, "Bruce, if you ever have a family member that you truly secretly despise, but you don't want to tell them that to their face until you're dead, just make them the executor for your estate." All right. It's generally not a flattering job. Some people love it, most people don't.
Well, thank you. Thank
Yeah.
you.
Yeah. All right. Cool. Guys, really appreciate it. Thank you guys for hanging out with me for an hour. We'll be back here same time next Tuesday. And next Tuesday, I plan to soft broadcast, no major details, new JV program that I have coming out. I'm going to try to announce it either later this week or next week on a separate workshop officially as well. So you guys be watching your emails. We'll be putting a JV program out where we work your leads with you. Within the next week, it's all structured out. I'm just putting my slides together to be able to run that workshop. Thanks, guys. Appreciate you.